But I just one thing. If the writ petition is disposed of, then how these orders could be passed?
Was it disposed of? It's a more fundamental question. It was not disposed of. Kindly see the order passed in the writ petition. And that's why the learned judge says, Milord, what will not be in other agency records saying disposed of is not disposal.
Mr. Bhattacharya, a lease has to be decided on the basis of what I allege and what is denied.
No, Milord, this has been decided by the division bench of this court that this is a public employment. The constitutional court, when finds there is some serious irregularities in public employment, constitutional court can go beyond that. This is decided by coordinate bench of this court and not has been challenged. Therefore, then I would like to place all the orders passed by the division bench from time to time. Therefore, the division bench will not say if the constitutional court finds that something is wrong, seriously wrong in the process of public employment, then the court can go beyond the pleadings. Something is called implied pleading. On the basis thereof, what did the court do? Court only directed to publish it. Whatever the records you have with your appointing authority. School Service Commission, court did not come to an independent finding. Court has directed the School Service Commission, that's why I placed the order, that whatever you have found, you publish it. The only apprehension which is genuine, Lord, I accept that before any order of termination is passed, they should be given a hearing. That is the only genuine approach that can be appreciated. But they want to avoid the court. There was no disposal of the writ petition. And even if it is assuming the learned judge was then considering 3 applications filed by other parties. If the parties come and appear before, they say, for the purpose of transparency, everything be disclosed. Why should somebody be affected? The writ petitioner did not get something for her own personal benefit. She suffered. But she wanted to know that why these discrepancies coming tip by tip. Let it be disclosed in totality. That was done.
But 261 is the answer to Mr. Bhattacharya. Page 261. That is the answer to Mr. Bhattacharya's argument. Page 261.
Lord, we have admitted
that there have been manipulations. That is what Mr. Bhattacharya is saying.
What has happened is CBI retrieved the hard disk from the agency which was engaged by.
Give an answer first, then you.
In a way, we have admitted. In a way, why we verified the record given by the CBI with our records, and the discrepancies were revealed, and we have stated before the court against whom these discrepancies came out. Those are the candidates who we are now being directed to upload their names, their list, etc. Though when
whose names you found to have been manipulated.
Yes.
This will be the list.
Yes. Now.
So that is based on certain data.
Yes, it is based on the hard disk which was sent to us by the CBI. That we have cross-checked with our.
It's on the basis of the hard disk.
Yes, that we have cross-checked with our database.
It's a way better for you to know that whether you figure or not.
Lord, this is Lord one of the issues which are pending in the Supreme Court. Please come to Lord page 190.
Even if it is published and your services are not terminated till the Supreme Court proceedings are decided.
Kindly Lord come to page 197. Kindly see Lord this issue is directly involved. This is the bench of the which is the subject from which the appeal is pending.
No, your SLP, what is a
SLP? I don't have a SLP copy, but I can show your lordship that it has a direct nexus. Please come to page 197. This is from the division bench. Lord, please come to the third paragraph. Similarly, has your lordship got that? The requirement of proof under 65B in regard to the particular nature of procedure is a requirement which can be satisfied at an appropriate stage and not fatal but curable, etc. So, Lord, this was not only argued in extenso, but this is, Lord, also the issue before the Supreme Court.
There was a writ petition saying that declaration. This is subject matter of challenge before the Supreme Court. Next page.
And in fact, page 202, your lordships will find this is the judgment which is impugned before the Supreme Court.
So this appeal is pending.
Yes,
appeal
this is
those
matters.
Those matters. From this appeal, the matter has gone up.
No, so the appeal
is disposed of.
Appeal is not disposed of.
One appeal disposed of.
One has been disposed. One appeal has been disposed. There were 3 appeals. One has been disposed of. The others are pending.
In one matter, the declaration was that OMR sheets are. This is also issue. Page 152. Declaration to issue that the purported OMR sheets published under notice are not conclusive and subject matter of proof before the following due process.
Please come to page 152.
This was a writ petition which has been considered in the
but
petition.
You have challenged this order before the Supreme Court.
Yes.
We have not. The affected parties have. We are similarly situated.
Oh, you mean this affected parties there?
The transfer petition is pending.
Lord, kindly come to page 152. This was the prayer in the writ petition, which is the subject matter in the special petition.
Page 150.
Kindly see prayer B.
There was previously
That is the
direction.
reason why I am humbly praying, Lord, that kindly, Lord, stay the process of this publication till the matter is finally decided by the Supreme Court. Whatever, Lord, the Supreme
The
Court is.
Supreme Court, is it deciding also this issue?
Yes.
No,
Yes.
no, no.
Yes, if your Lordship wants,
I will
I
go.
can.
I have annexed the writ
If
petition.
your Lordship wants, I can produce, Lord, the SLP copy. I don't have it today with me.
In the SLP, this ground is taken.
No, but I don't know the ground is taken or not, but they are trying to argue this point. It's admitted position. They have been trying to argue this point that these OMR is as if it is a criminal trial, therefore OMR sheet should be proved in the criminal court. That's the tenor of argument. But in case of appointment, below the prima facie material which discloses that the appointing authority admits these are all manipulated. Therefore, below, this has nothing to do with criminality, and the argument which they have been trying to advance to the Supreme Court relates to criminal law, not with the below appointment which is governed by Article 14 and the rules.
But it's one thing that so far as the
But even then, below, even if the Supreme Court considers the publication below is not in any way affecting the issues to be decided by the Supreme Court. Publication will not really make the issues precise. We can get to know who are the ultimate persons to be given hearing.
What will know who is
there has to be a finding because this issue has been raised in Gopinath Bhanju's case, the writ petition at page 134.
Yes.
An issue has been raised that a declaration to issue that the purported OMR sheets published under the notice are not conclusive and are subject to proof. So if they are not conclusive, then what would happen? So
that has to be not. This might be argued, but the OMR hard disk is conclusive without any doubt in mind, and that is accepted by the employer. The School Service Commission, by filing affidavit, says yes, we have compared. There has been manipulation. That is affidavit before the division bench of this court. But I would like to place the affidavit. Therefore, so far the appointment is concerned, this is conclusive.
But why the School Service Commission has said?
Yes, in an affidavit filed by the School Service Commission, even before the Supreme Court, that Mr. Dr. Patra has argued that we have compared and we found this manipulation.
Yes, Dr. Patra, have you said so?
My lord.
What Mr. Bhattacharya is saying, was it your stand before the Supreme Court also that you have compared and found it to be manipulated?
My lord, what has been submitted in the Supreme Court, I don't know.
No, but Mr. Bhattacharya said.
But we have filed affidavits, that is correct.
Yes.
We have throughout submitted, and even in some of the cases filed affidavits stating that yes, we have compared and there are manipulations, and that we have admitted. Up to that extent we have admitted. We have also admitted in the affidavits that NICER was our authorized agent who carried out the task of evaluation.
No, which affidavit? Can you just show us affidavit that you are?
Lord, then on the next.
Yeah, we shall hand over an affidavit. Achha, did you
never been circulated. I have been appearing for 6 weeks, 7 weeks. It is never circulated.
No, it is already disclosed in Supreme Court. In the affidavit, their own paper book, this is there.
No, it is not there.
The employer should be in a best position to say,
yes,
supposed to maintain a neutrality.
I understand.
So if a neutral body has come with a thing,
the employer,
so
what the employer is saying is that as handed over by the CBI, we are doing this.
OMR sheet may be published, but the authenticity conclusiveness
handed over by the
left open
CBI.
until the matter is decided by the Supreme Court.
That the OMR sheets. My lord, may I just show two orders, my lord. First,